The meaning and significance of commercial scale for the criminal provisions in Part 5, Division 5 of the Copyright Act has, over the years, been quite difficult to ascertain, and even more so to apply. This video intends to briefly explore the meaning and significance of this peculiar inclusion into copyright legislation by breaking the issue down into the two obvious parts, meaning and significance. First, let's look at meaning. The various sections of Part 5, Division 5 of the Copyright Act outline criminal offences where copyright infringements occur on a commercial scale. The Act provides that in order to determine whether an infringement occurs on a commercial scale, the following matters are to be taken into account: the volume and value of any articles that are infringing copies that constitute the infringement or infringements, and any other relevant matter. So the question becomes, at what volume or what value of infringing copies is commercial scale constituted? The answer is, well, unclear. According to some, the provisions in the legislation are puzzling and a swamp. Commercial scale has not been successfully applied. This is because the provision is only intended to apply to the whole copies of the original subject matter that have been made and distributed, whereas this part of the legislation is mainly applied to cases where there has been a complex system of file sharing, which does not involve entire copies being made. Rather, part copies are made by many parties, and the end user can then combine these shards of original copies to create their own copy. This is known as peer-to-peer sharing. All in all, the meaning is relatively straightforward. In a committee vote of the European Parliament regarding an EU directive to take action against those making intellectual property infringements, a rapporteur themselves had proposed a definition of what commercial scale meant. Their straightforward definition focused on the intent to obtain economic or commercial advantage. They made a distinction that this would likely not be personal users making copies for their own purposes. So, what's the significance of this murky inclusion into the legislation then? The words commercial scale were included into the Australian copyright law by way of the Australia-United States Free Trade Agreement. One part of this agreement was that Australia makes some legislative changes with regard to the criminal penalties for copyright infringements. Specifically, the criminal procedures and penalties in relation to willful importation or exportation of copyright and trademark infringements on a commercial scale. The significance of this inclusion was that it would give the courts greater power to increase damages. However, due to the difficulty in application of this provision, it has actually made it more difficult for the judiciary to enforce their obligations under the FTA and the Copyright Act. The take-home message from this video is that unless you're copying a file purely for your own uses with no commercial or economic intentions, then you should reconsider. Thank you.